Are you aware that as a husband or wife, the law does not allow you to go to the bank and demand details of your spouse because you are married? It's not allowed. So if you open an account with a bank, the bank is mandated by law to maintain secrecy of your account information. What it means is that the bank cannot give out information on the account unless there are some four exceptions. So today I'm going to talk about the four exceptions under which a bank can give information on a customer. The first exception is that the bank can give information about a customer when there's a court order. So when a case is ongoing at the law court and the court writes to the bank that they want a particular information, that order gives the bank the obligation to give information on the customer to the bank, the court or the institution that is asking for it. So that's the first exception, the court order. The second exception is what we call the public interest. So the bank can also give information on a customer when it's in the interest of the general public. So let's say there's again something happening that the bank needs to bring out an information to save the state. The bank without a court order can still do that. However, this exception has to be managed carefully. So it's not every public interest that must be activated by the bank. The third exception under which a bank can give information on a customer is when the information protects the bank against fraud or any legal tussles. When the bank feels that this information will help them to be able to clear their name with a fraud, then the bank is allowed to give that information. Again, this exception has to be managed carefully by the bank when they give it out. The final exception is through the customer's own written instruction. The key word here is what? Written instruction. What it means is that the customer should write to the bank to give out that information to the third party that is requesting for it. So let's say a customer is going for a loan from one bank. In the loan application, the customer will have to sign a disclosure which says that that bank can get information about the customer from another institution or a bank. In that case, when that institution goes to your bank to get the information, the bank can give it out because there's a written instruction from you to the bank to give out that information. So these are the four exceptions under which a bank is allowed to give out information on a customer, which does not break the issue of secrecy. Without these four factors, a bank is not allowed to give out information, whether you are the brother, you are the sister, you are a relative, or someone is dying. The bank cannot do that unless there are these four exceptions. So sometimes you find people who are secretaries to a company or people who deposit money into a company's account. Even if they deposit the money into the company's account without written instruction, they cannot go to the teller or the account officer to demand balance on that account. It's not allowed unless the company has given that person written instruction that when this person comes with this ID and they are requesting for account balance, give it to them. So the teller over the counter cannot just mention the account balance because you deposit the money every day. It's not allowed. It's only allowed under these four exceptions that I've mentioned: by court order, public interest, the bank's own interest, or the customer's written instruction, and not a voice call. So when you call the bank for them to act on that level, the bank will not act on it unless you have written to them either a pen, letter, or mail. Without that, your account information will not be given to a third party.